Hey, Brian Parker here with another exciting video. I just did a video on counterclaims. Let's put that up there. Counterclaims, zoop. And there's a small ventured into area called cross claims. And that's not always coming up in a debt collection context, but it does. And there's one special scenario that I hear a lot of, especially when someone has accumulated credit card debt with a spouse who's now an ex-spouse, and there's a divorce agreement that says, okay, one spouse will pay all of the credit debt. And now you have this agreement, which, by the way, has no legal consequence to anybody, like the credit card company or anybody that says, hey, I don't have to pay this because I've got this divorce decree, is wrong. Because unless you have an agreement with the company whose debt you're eliminated inside the divorce agreement, that company, that debt collector, that loan company still has the right to go after both of you, even though inside the divorce decree it says spouse A will pay for spouse B all that credit. So that has no legal significance to anybody that's not party to the divorce decree. If Square Deal Dan signed off on that divorce decree, then indeed he can only go after spouse B. But today we're going to be talking about suing spouse A and spouse B to entertain and visit the context and the concept of a cross-claim. What is a cross-claim? Let's put it up there for you. A cross-claim is a lawsuit between parties already aligned on the side of the V, meaning Chase sued Mr. and Mrs. Smith. They were married when they got the Chase card. Now they've parted, but Chase doesn't know that or care because they weren't part of the original divorce decree saying only party A pays for the credit. So they sue both. A cross-claim, especially where one party says, hey, wait a minute. He took my name, he signed my name on all these cards, now I'm on the hook. Chase doesn't care. So what you do is you do what's called a cross-claim. So remember, the counterclaim was JP Morgan suing you, and you counterclaim saying, well, wait a minute, Charlie, you don't own the debt, and you've sued me wrongfully in the wrong court, past the statute of limitations. They say cross-claim, you're going across the V. So there's a V between you and JP Morgan. There's a counterclaim. So a cross-claim is you and you. So JP Morgan versus you and you, spouse A, spouse B. A cross-claim is you're not going across literally to JP, you're going across each other. And I'll show you how that caption sets up. So when two parties are being sued, if there's reason, both the co-defendants can sue each other on a cross-claim depending on liability. It's really a lawsuit between the parties, and I say that because you could go outside of this and sue party B, so party A could sue party B, but you wouldn't do that. You've got everything going right here, and it saves you some cash, and everything is involved in the same case. So that's authorized by usually every state statute, including your federal statute. Remember we talked in my counterclaim video about mirroring. Most state court rules are mirroring federal court rules. They have deviations and they have a right to, but it's right there. Everybody uses templates, right? So the states will commonly use templates of the federal rules and write on that. So, but they must rise out of the same transaction, meaning the underlying action, what was it? Chase is suing you and you because of the credit card debt that you're both on the hook for, even though there's some evidence that A signed the name of B or B signed the name of B without the authority. They were married, JP Morgan doesn't care, but it must be out of the same transaction or occurrence. And unlike counterclaims, which are compulsory, you better bring them or you're going to lose them, it's permissive. You can bring them now, you can bring them later, but there's SOL ramifications to that. I say bring it all at once, whether it's permissive or compulsory, bring it all, bring everything, just bring everything. So here's why they matter. Shazam, when I say matter, cross claims matter. It's a way for you at the time you're being sued, if there's an indemnity agreement or indemnification agreement. So that divorce decree where spouse A said, I'll pay all of spouse B's credit debt as part of this, that could be looked upon as an indemnity or indemnification agreement where party A is contracted to pay all of her debt. Now she's being sued on something the man falsified her name. So that is a guarantor in a sense. So that's what, and the concept, legal concept is seeking contribution. It's exactly how it sounds. Hey, I got to pay this thing. I'd like you to contribute. Okay. Well, in law, it's called seeking contribution, and that has very large legal ramifications. Just the word alone. In law, you know, they're going to be seeking contributions. Big. So there's also another way that I rarely see this. I'm going to show you why. Let's say Square Deal Dan debt buyer sues party A and party B, and also sues the person that sold them the debt when they discover that the debt they were sold is worthless. Neither party A or party B owes the debt. It comes out. So they sue the assignor of the debt to them. That's a cross claim. That doesn't happen much anymore because if you remember all the work we've done on chain of titles and bill of sales, they place those debt sellers, the person that is potentially on the hook here, they say, we're giving you this debt without recourse, you take it. And so that's why the Square Deal Dan debt buyer bought it for pennies on the dollar. He bought it without recourse. That's why that's in most bill of sales. So they know they're giving them junk and they know they're on the hook legally. So they go, you're buying this without recourse. That's why you're paying pennies on the dollar. But without that language, Square Deal Dan debt buyer can sue the assignor. So that's a way for Square Deal Dan to initially sue party A, party B, and the assignor. Now you've got a whole bunch of stuff, whole bunch of cross claims you can do. So you remember also, you probably don't, but I have a video on third party. So in my head, when someone asks me about this week, hey, do a counterclaim, I go, hey, there's 3 videos there. I already did the third video, which is, interestingly enough, third-party claims. Let's just put it up there, how to do a third-party claim. There's a good way and a good reason why I do that. If I sense that no one is listening to my cause of action and I really want to cause problems, I start suing third parties. So let's say in that case, that third party, let's put it up there, third party video. In that case, Velocity was giving me a hard time and I could see Upstart was really the bad guy, if you will, and they had legal consequences that everybody was ignoring and just saying, no, Velocity owns this and you, debtor, owe it to us. So I thought, how am I going to fix this? No one's listening to me. I sued in a third-party action against Upstart and against the trust, the Wilmington Trust. That caused a whole bunch of problems. Eventually, I got the whole debt gone without telling you anything of a release or anything. And both the attorneys and my clients were very happy because I brought these people in the mix because I wasn't being listened to. So I had a legal good reason to bring in Upstart. And that caused a whole bunch of problems. Suddenly all these lawyers started popping up. And sometimes you like lawyers to pop up because they're like, they don't give a damn about most of these big firms. I don't sense that they really care about their clients. It's just a billing opportunity. But once you start punching them and they've now got to do all this work, now they have to go tell their clients what's going on. And that settles cases. So cross claims, as I made the point yesterday, 2 days ago on the counterclaim video, it's leverage. You don't do it for leverage, you do it and now you have leverage. You have to have a good faith reason to bring a cross claim, counterclaim, third party claim. Follow the rules. So that's in a nutshell what's going on with cross claims and why they matter. If you've already got a judgment against you, and now there's a garnishment. It goes to your bank. Your bank in a lot of states to enforce, so you owe a judgment, the bank gets the judgment from the lawyer and says, we've got a garnishment, a writ of garnishment against your customer, pay us all the money in 28 days that he has in his bank account that meets this judgment amount. But what they do is they send what's a writ of disclosure, and they send the writ of disclosure to the bank and say, put a hold on these funds and also tell us everything we need to know about these. You know, when did he have the account? Does he share the account with anybody? Tell us how much is in there. And the bank immediately puts a hold on the bank, on the amount that is looked for. And it must, the bank, who's now called a garnishee defendant, the minute the writ of garnishment of your bank hits the bank is now a garnishee defendant. The minute the writ of garnishment hits your employer, HR gets this, they're now a garnishee defendant. Why am I saying that? Because in a lot of states, the rule is, if you don't tell us what we need to know, this is the lawyer saying to the new garnishee defendant employer or bank account, they are on the hook for the whole amount. So if something goes wrong, I'm not saying look for this. If you have a judgment against you, your bank or your employer is on the hook now for the next 28 days. If they don't respond to the writ of disclosure and send the lawyer everything he needs to know, he's allowed to ask once there's a judgment. In a certain amount of days, your bank has to pay your judgment. That's the punishment. So when your employer gets a garnishment, and I've done plenty of garnishment videos, there you go, there's a couple of them. When your bank gets that garnishment, they're pissed at you, right? And it may be a wrongful judgment and garnishment and all of that, but they're pissed at you because now they're on the hook for the whole thing. So what am I telling you that for? That's a certain point where there could be cross claims. So it's a judgment. Now a garnishee defendant says, oh shoot, I got 28 days to give out this information. Your bank now has 28 days. And the bank knows we're totally not on this and this is wrongful. They could sue in a cross claim against the employer or the employer against the bank for whatever reason. Stuff comes up. So you got to watch out for that. That's another way of a cross claim that you have absolutely nothing to do with. The judgment's gone, you're already liable, but there are possibilities in debt collection cases of cross claims like that. So if more than one garnishee, that's a bank, an employer, and somebody else is pulled into a garnishment, their obligations overlap and conflict, they can sue each other. Then it gets to be a whole mishigas. It's a mess. So one of the good things about having a cross claim is it is procedural efficiency. If every dispute that can be had comes out, it stays under one umbrella, one court. You're not shooting off to other cases, and a lot of cross-claim defendants their cases can't be removed to federal court, as we talked about in counterclaims. So go take a look at that video again. So when do you file your cross-claim against your former spouse or the other defendant? Right away. The Parker way is right away. The statute of limitations, let's say you got a year to file a cross-claim, it doesn't stop. It keeps running even with a cross-claim. You just don't want any mess. Let's say you do a answer, but you don't do the cross-claim, and then 8 months later you go, oh, I should sue my fellow defendant. It's getting too hot here. You may have missed the boat. The only way to get out of that statute of limitations issue is you can say, if you take a look at my original pleading, it combines this new cross defendant in the facts and pleadings, so the court may let you have a statute of limitations exception there. So when we talked about counterclaims yesterday, I said you got to bring it or lose it. It's compulsory. But if you do an amendment of just the answer, you can then, if you get granted the answer, well, you got time to do the cross claim that you missed out the first time you had an answer. And I told you of a tricky way, another way to do that. But In these cases, if you didn't bring the cross claim, you are out of luck if the statute of limitations has passed when you do bring it. So always bring it with the answer. When you are drafting the cross claim, I'm going to show you a cool thing. You're in the same court. So let me just do this now. I'm jumping ahead, but I'm going to do this now. So here is the caption, Shazam, of how to draft a cross claim. So it's your basic thing I introduced to you with the counterclaim video, but look how it's broken down now. So I've written the underlying lawsuit. So that's Midland versus debt buyer, David Debtor and David and Dorothy Debtor. They were married at one point, now they're not. The thing just blew out because it got overheated, but I'll quickly finish this. The caption shows that Midland Credit is suing Dorothy Debtor and David Debtor. So what we do is when David Debtor is suing or is being sued by Dorothy Debtor, we separate the captions, we let the court know it's a cross claim, we let the court know the underlying lawsuit, and we shape our pleadings so that everybody is alerted. So what we do with that caption is we keep the original case style and case caption and also the plaintiffs and defendants, but we just title the defendants with different names. Of course, the case number is the same. We keep it all under the same umbrella, so there is not increased costs for anybody. Someone can complain, go, oh, now I'm gonna have to pay all this. Well, if you have a justified reason for suing or cross-claiming someone, they can't complain about the costs. But if you start adding to the cost by starting a new case, it's gonna come right back. So you keep it all under the same court forum umbrella. You separate the parties or actions with horizontal lines as I've shown you there. And again, you keep your cross-claim caption, and you can add more third-party counter defendants. But the point is, if you've got a good reason to go after somebody else for contribution, then you keep it in the same case. It's more efficient that way. One of the leverages you have in a cross-claim is the ability to settle. So when you're being sued, you and your co-defendant, you've got your answer, you've got your affirmative defenses, and you've got your way out of this. But if you have a good faith reason for cross-claiming, you can then go to the plaintiff, let's say Midland Credit, and go, look, she's on the hook, I'm on the hook, or she's on the hook, someone's on the hook because of this divorce decree. Remember, when you have a divorce decree and it says party A will pay party B's all their debts accumulated during the marriage, it isn't good as to Midland Credit or the original creditor unless they signed off on it, which they didn't. But now with the cross-claim, you can say, look, if you allow us to do all this fighting, you're going to get dragged into this, and both of us are going to now go after you and look into your socks and find out what's really going on here. It also increases your costs. As it's a $6,000 debt, you're going to pay more in attorney fees and costs than the actual debt, which will probably settle out anyway, maybe. So let me go. Party, the cross plaintiff says to Midland, the original plaintiff, let me go, and any money I get, I will turn over to you. I'll help you. You can get out of the case, and I'll make sure that you get the check. And they may let you go. That's a leverage for them. They have to spend no money, because that's always the issue when you answer right, the right way, the Parker way. You accumulate costs for them. So when someone sees me on the caption, no offense, I'm not being big-headed or anything, they will usually just settle unless it's a huge debt justified. Sometimes, no matter what the amount is, they'll bully me. It happens every year. A big firm comes in and goes, Parker's getting away with nonsense. But not with Midland. They're very pragmatic. A lot of people are pragmatic, and my clients benefit from that. But you offer a walkaway to plaintiffs. Go, let me out. It's really, he signed my name, here's the proof. And now you get out. If you're the good guy in this case, because your ex-spouse signed up for you, you can get a walkaway, whereas you wouldn't if you didn't have that cross claim. And the collector will bite at that to lower their costs, because it's all about costs. They don't want to spend thousands for something they paid pennies on the dollar for, and now with you being smart, the payoff for them is just not there. So you just remove the financial bullseye from you to the real bad guy that signed the name. There's a discovery synergy there. You can do your lawsuit, give all the discovery to plaintiff on the sidelines. When I go after someone with a cross claim or a counterclaim or a third party claim, I sit on the sidelines and just watch these guys go at it, and all the stuff they squeeze out between the two or three of them, it's good for my case. They're all, so before they're saying Parker owes the debt, therefore he must pay us. Now when I sue them, they are fighting about who owes the debt to whom and where's the chain of title. Nothing good comes out of that for them. Everything good for me, because all the stuff that where they got to prove, the finger pointing means I get my proof that one of them is liable and one of them has no reason to sue me. So there's a synergy there. Your discovery or their discovery can help you. You stay in the same venue. If you represent both defendants and one is more liable than the other, it's, as an attorney, a conflict of interest to represent both. Don't do that cross-claim unless you've separated yourself. That's my advice. But the evidence overlap is just going to benefit you. With a cross-claim or lots of claims on the other side, you just let them do all the work or you take a chair. So there are great things to be had with these third-party claims, the cross-claims, and the counter-claims I've shown you in 3 different videos. Enjoy them. Have a good faith reason for bringing them, but the reason you're bringing them is because you're not completely liable. You're seeking either contribution or the claim paid by someone else. Go to killdebt.com for this and other great videos. Remember, killdebt.ai is coming. It'll revolutionize the way you defend yourself. Members, current members, will not have to pay the premium price of new members in June of 2025. It's not going to be a high price, it's just going to be more. Current members, I have members of this site, bless them, launch members that pay a third of what we're charging today because they've stayed with us all the way through. They got what's called the launch price. This is the new launch. This killdebt.ai will be revolutionary. It's going to, all the work's going to be done for you. Just put we're going to have a marriage, you and I. My quirky 30-year brain of how to do this and all the pitfalls and the tricks with your facts and your state rules. Married together, and out pops the document you need to do a cross-claim, counter-claim, third-party claim, lawsuits, federal lawsuit, whatever it is. The AI will use my brain, not the web, because what I've noticed with ChatGPT is none of their stuff. They're really good for setting stuff up, but the case law, as it stands today, is not catching up to the technology. And most of the cases that I see, I have to check, double check. And you've seen great videos on that where lawyers don't check. I do, because it's not safe right now. There's so many mirages. But in Parker GPT, let's have the little airplane going by, Parker GPT, great Parker training. It will be just my brain, my consciousness. I can be dead, and it will be there for you, working hard for you. Check it out. It's coming June 2025. Great prices either way. Thank you for watching. I hope this is a little bit better understanding of cross claims. Thank you. Bye-bye.